oh, there was a contract. There was a contract. Here's an affidavit. There was a contract, so we're good. However, in this case, for example, there is a counter affidavit, if you will, saying there was no contract. Not only that, there was a company policy forbidding oral contracts as it has to deal with employment.
Let me ask you a quick question on the contract. It's not your position, as far as I understand it, that if there was a contract that they didn't perform or that you did perform. It's your position that there was just no contract.
It is our
Right.
position that there was no contract.
I know that is your position, but is the other part of what I said also accurate? That you aren't arguing if this contract did exist, that you somehow, your client complied with it?
We're not arguing this, but if we were arguing that a contract would exist, that would be one of the 4 essential elements for breach of contract.
Right.
We'd still have the opportunity to argue no damages. But in this particular case, because the appellee depends on this theory that an oral contract existed, and we've rebutted that and provided additional information, I don't want to say evidence, but in the affidavits, that, look, the company policy even forbade that. That should have been considered, and that goes to your question about the summary judgment. I mean, the trial court should be able to consider both sides' affidavits and balance that when determining if one side has made a prima facie case.
So in your understanding, if the affidavits contradict each other, they cannot assert a prima facie case?
I think it would depend on the weight and the credibility of the information presented in the affidavits.
Before we run out of time here, I'd like to take a step further back and talk about the applicability of the anti-SLAPP statute to this case in the first place.
Okay.
My understanding of your argument is basically in both of the cases is that the employees' wage claims to the TWC was an exercise of their right to petition.
That is correct, Your Honor.
Now, that's a statutory right in this case, right?
That is, Your Honor.
It's not a constitutional right. There's a statutory mechanism in place for an employee to make such a complaint and get relief from the TWC.
Yes, Your Honor. And may I address that further?
And
Sure.
I just want to make sure I understand. And in that regard, in regard to this statutory scheme, the employer has the right to later challenge that in court.
Correct.
And of course, independent of that right, for example, hypothetically, if an employee had been embezzling from the law firm, just hypothetically, and stole $1 million, they wouldn't have to. The employer wouldn't have to go to the TWC to file a lawsuit against the employee. They could go straight to court.
That's correct.
So my understanding here is your entire argument that the anti-SLAPP statute applies is based upon the mere fact that both of these employees had filed complaints with the TWC.
Except, Your Honor, that it isn't the mere fact. It is the fact. Because the plain language of the text of the TCPA says that it defines that exercise of the right to petition. It goes a little further than just our understanding of constitutional rights and actually expressly defines it.
And yours is under the right of petition, not free speech or association.
Correct.
Right?
A communication in or pertaining to an official proceeding other than a judicial proceeding to administer the law. The payday law, the Texas Labor Code specifically says that it is the purview of the TWC to, and I quote, this is 61.002, administer this chapter, which refers to the payday law. Right. And so by...
And the only reason these employees had any right whatsoever to petition the TWC is based on this statute. Otherwise, they would have to seek a common law remedy and sue their employer in court.
I understand to be correct. Yes, Your Honor.
Thank you.
I have one more question before you sit down. So there, as far as I understand, there are some factual differences between the two cases.
Sure.
And one, for instance, is the fact that Martin was charged with keeping records of attendance, and Porter Garcia did not have that responsibility.
My understanding, although the record should be more reliable than my understanding, Your Honor, quite frankly, is that they both had duties that overlapped and that there may have been an overlap in that area. My understanding of the two significant differences in the factual background is obviously the amount in controversy, the amount that was awarded by TWC for each differed, and also one of the appellants, I believe it was Martin, put in her affidavit that a representative of the law firm stated, you either drop this wage claim or we're going to sue you for other things. That's the only difference that I'm aware of materially in the factual background.
Well, let me come, thank you. And let me come back to the keeping the record. Do you see that as potential, tell me why that is or is not potential circumstantial evidence of knowledge or intent in a fraud claim, and whether it matters that there are different responsibilities on Martin and Porter Garcia?
As to fraud, I think we have to look at the petition and determine what it is they're contending made up the misrepresentation, the fraudulent statement, if you will. Initially, when this lawsuit was filed, the Appley law firm argued that the fraud was a misrepresentation to Texas Workforce Commission. Then, after we filed our motion, our anti-SLAPP motion, the petition was amended and their argument changed to the fraud or the misrepresentation was that they had represented to their employer that even if they missed work, they would make it up at a later date. Our position on why that's not possible, or at least doesn't fit into the elements of fraud, is because the appellants would have to have had foresight at the time that they were hired, at the time that statement was made, that at some point in the future they would have missed, they were planning on missing work, and that they were just waiting for the opportunity to do so. And that doesn't really fit with the timeline here. The timeline here is they quit their jobs and had one last paycheck due to them, which was refused. It wasn't paid. And in response to their wage claim, it was alleged, oh, well, you had entered into an oral contract with us that said that all that time that you missed, you were accruing, time off for that, and so we don't owe you. The problem with the fraud allegation, Your Honor, is that it suggests that they knew at the outset, when the representation was made, that at some point down the line, they would have not followed through with it. And that's just not supported in the affidavits on file.
Okay, and the allegation that Martin was tasked with keeping attendance records and didn't do so, you don't think that moves the ball? You don't think that's a distinction between the two cases that matters?
I do not.
Thank you. We're taking you a little bit over, but you'll still have your remaining time for rebuttal.
Thank you, Your Honor.
May it please the court. Your Honors, my name is John Woods, and I represent Travis Law Firm in these appeals today. And Justice Jennings, as you noted, the cases are still technically separate, but we're addressing both. If I give record sites, I'm going to try to say Martin and Garcia for clarity, but if I skip over that, please forgive me. This is an employment dispute that occurred between an employer and an employee. All of the facts, and one of the key things to look at here is there were 4 causes of action in the petitions in the underlying lawsuit. One of those is the appeal of the TWC wage claim. The appellants did not file the TCP or anti-SLAPP motion as to that. They filed it as to the breach of contract, to the fraud, and as to the theft claim. Those are the only 3. All 3 of those cases are based on, related to, and in response to facts and circumstances that occurred from the time of the interview to the time that the employees quit their employment. If there were a motion in limine in the trial court that said you can't talk about anything that happened after they walked out that door, that lawsuit would still stand, and quite honestly, it would streamline the trial.
Well, you might still have a lawsuit, but your pleadings go beyond that. Your pleadings capture things that happened after that.
Yes, Your Honor. And in order, because of a later in time event that was undertaken solely by the appellants, the movements on the motion to dismiss, because they filed the TWC claim. The way that the case law is, Justice Massengill, just as you noted earlier, there's an Eigel case that we cited, that our reading of that and the other case law, it appears that we had to bring the other 3 claims that are the subject of our hearing today and the subject of this appeal, that we had to bring all of those together with an appeal of the wage claim determination, which we also read it as we had to exhaust our administrative remedies and then file the petition in the trial court with the other 3 claims. So you are correct that the petition goes beyond that, but in order to bring our 3, we had to mention the TWC, because if we had just let TWC lie and not challenged it in regards to appellant Porter, or I'm sorry, appellant Garcia, she was there for less than 90 days, and when the legislature amended the labor code to only give jurisdiction to the TWC for 180 days, arguably we would have absolutely had res judicata against her. Now, as to Ms. Martin,
The only reason it matters is that's what ties your petition or makes your petition relate to the proceedings that happened in the TWC, which gives rise to the argument that you're subject to the TCPA.
yes, Your Honor, and we don't dispute that the filing of the TWC claim put the umbrella or the kind of the taint of the TCPA. It colored all of these other claims that we had independent of TWC, changing the facts just slightly. If we had filed our lawsuit the day after the appellants left the Travis Law Firm, if we sued them for those first 3 causes of action, because we didn't need anything else to pursue those cases, and then the appellants went and filed their claim.
Are you trying to argue that somehow these underlying facts, since they took place before the TWC proceeding, that somehow avoids the operation of the TCPA?
Yes, Your Honor. And it is through much thinking and trying to make it. I've tried to synthesize it in the best that I can come up with.
Well, I haven't even heard you articulate the argument, but I guess you would need to persuade us why your pleadings don't control the question, to the extent that your pleadings explicitly refer to and seem to suggest damages arising from those proceedings. I don't see how you escape the conclusion that these claims relate to the ex-employees' exercise of their rights in the TWC proceedings.
Because, Your Honor, our damages do not stem from the TWC petitioning.
That's not what the pleadings say.
Well, no,
Aren't you seeking the same amount?
no, Your Honor.
You're seeking the amount that was awarded.
We're seeking in excess of that.
But you're seeking that amount, the amount that was awarded in the TWC proceeding for each case.
Yes, Your Honor, and if I could explain why. Because I understand what you're saying of if we had said we are suing them for the amount that we had to pay them because of TWC, TCPA applies, no doubt about it. But what happens here is, as shown in the record, the appellant Martin, it was like 17 and a half days. That was far in excess of what was covered in TWC, both in dollars and days and that 180-day jurisdiction. As to appellant Garcia, she availed herself of the statutory remedy of the payday laws, but that statutory remedy of the payday laws is not a full and final adjudication of an oral contract that we had between the company and the employee, because we were actually barred from arguing in the TWC that we have this contract that said this is okay, because under the payday laws, it says that you may not withhold wages. It doesn't say that you cannot have an agreement to do this. It says you cannot hold it unless you have it in writing. So in the trial court, we would still, at a minimum, be allowed an offset under our breach of contract, that if we had to pay under TWC, then under breach of contract, which is again from interview until the time they walked out, we would still be entitled to that offset that has nothing to do with TWC. We would be entitled
Were the
to that.
TWC proceedings fighting over the same wages?
I'm sorry,
The TWC proceedings, was the fight there over the same wages, the same days missed?
Well, as to appellant Martin, the one that had 17 and a half days, no, she had a much broader scope. But as to appellant Garcia, yes, it was the same, because she was actually there for less than 90 days, and TWC has a purview of 180. So, yes.
If you don't mind, I'd love to take you to the second prong of this, which is whether there's a prima facie case.
Yes, Your
And I
Honor.
have a few questions for you on that.
Yes, Your Honor.
With the contract, for Porter Garcia in particular, your affidavit says that for the law firm to perform under the contract, you had to pay Porter Garcia through September 8th. your pay records show only 14 hours of payment in September. Can you explain to me, A, how to reconcile that, and B, whether it matters that there is that conflict for purposes of finding a prima facie case?
I would go to the second one first, and then I'll if I could, because I think that would maybe help me in my mind. Under the prima facie case, the only thing that's required is a prima facie case is an establishment through clear and specific evidence, and clear and specific, it has to be direct. Direct evidence is payroll records. If there is an issue of the appellant saying, well, no, you're not entitled, you can't sue us for $500, but you can sue us for $300, that wins. When the appellant says that there is a fact dispute, we submit that the case law is very clear that they admitted that we have carried a prima facie case. Because by way of comparison, steps 1 and 3, the burden is a preponderance of the evidence. It's the same fact-finding standard as a jury would, or as the fact finder would have in a trial court. The first one is whether or not it applies. Step 3 is whether or not the appellant or whether the movement has an affirmative defense. The second step, which is where we come in to show the prima facie case, everything I've read in the case law says it is in procedure very similar to a no evidence motion for summary judgment, where I'd heard somebody tell me one time.
Can you tell me a case that says it's similar to no evidence summary judgment motion?
Well, Your Honor, I think the Lipsky case, I don't know.
Go ahead.
Right. Well, that's what I'm saying. I don't know that I can give you the case that says that, but I'm just saying from all of my reading of the cases, it says, okay, once you get into step 2, the non-movement kind of sits down, and then, the movement, here the appellant sit down, the non-movement, us stands up, and the judge says, go. If you've got 4 elements, you've got a hook, and you've got to hang evidence next to each one of them, and that the movement doesn't then get to come back and say, well, no, look at our evidence. Our evidence is better. Believe us. If it were preponderance of the evidence, which is steps 1 and 3, that would absolutely be the analysis. But because the stated purpose of the TCPA is to not only protect constitutional rights, but to protect the rights of persons to file meritorious lawsuits for demonstrable injury, that's where we come in, is in that second prong. And I argue the first prong, too, of our constitutional rights in the open courts. But we just have to hang the evidence. Now, I'm sorry.
If we assume, taking everything you're saying is true.
Yes, Your Honor.
Can you walk me through, for your fraud claim, walk me through for your fraud claim for each of the 2 people?
Yes, Your Honor.
What evidence is there of knowledge of the falsity, and what evidence is there of intent?
Yes, Your Honor. And that's actually the second two prongs of fraud. As to, there's a knowledge of the falsity was the first one, and then you said the second was intent. Knowledge of the falsity, there is a commonality between them. As to Appellant Martin, it's clerk's record, page 78, paragraph 14. For Porter Garcia, it's clerk's record 85 through 86, paragraph 10, where the affidavit, and I believe the petition as well, but I mean, which you can consider the petition or the affidavit, they're the same thing. It's not, that's how it's different than a summary judgment for sure. It's actually a wider things that you can grab from. States how they repeatedly made, how the appellants repeatedly stated they were aware of the policy, that they were getting paid even though they hadn't worked, and that they knew that they had to make up the work.
How does that show they knew at the time that the statements were false?
Because circumstantially, it comes from circumstantial evidence. There's not a direct piece of evidence that we can point to, as in basically every fraud case that says, hey guys, let's get this out of our employer.
But what is your circumstantial evidence?
The circumstantial evidence is the repeated statement of the policy and the repeated agreement with the policy and understanding of the policy, still taking the work, and that the appellants never made up any time.
Hold on. So what is the fraud?
The fraud the fraud of the knowledge or the recklessly as a positive assertion without knowledge of the truth prong of the fraud claim is the repeated telling the employee you're getting paid even though you didn't work, but you need to make it up, and the employee saying, yes, they understand that, and that it was repeated to the degree where it is clear and specific evidence circumstantially.
You're saying that the employees made fraudulent statements that they understood that they needed to make up time privately, knowing that they didn't intend to actually do it?
Your Honor, that is our argument, that it's circumstantial evidence. Now, I mean, circumstantial and direct, we as trial lawyers prefer direct evidence, but we know that circumstantial evidence, and there is case law that circumstantial evidence is allowed in a TCPA motion.
Understood that circumstantial evidence is allowed. It strikes me as in the Martin case, you have the alleged circumstantial evidence that she was supposed to keep these records and she didn't keep them. What do you have in Porter Garcia that's circumstantial? Somebody telling you, you have to make up the time, you have to make up the time, you have to make up the time. How is the fact that you're told 100 times you have to make up the time circumstantial evidence that you knew that you weren't going to make up the time?
Well, and you are correct about Appellant Martin, that she had the whole timekeeping thing, and that's what I didn't touch on before. That is the difference. She was supposed to keep the records. She didn't keep them. That's evidence that she was going to cover up her fraud, circumstantially, again. As to Appellant Porter Garcia, that is evidence. Our argument is that that's circumstantial evidence, because if it was said in the job interview and she said, okay, and then there was no allegation that it was ever said again, that...
Circumstantial evidence is evidence from which a fact can be inferred. And here, what you're asking, or what you're suggesting is that a fraudulent intent can be inferred from an omission to do what?
To make up the time. That the repeated thing, that what we would ask at this stage with no discovery, no depositions.
But you're kind of making a circular argument there. The fact that she didn't make up the time, you're saying from that you can infer that she didn't intend to make up the time, as opposed to just either negligence or some other reason why she didn't make it up, maybe an inability to. What you see what I'm getting at?
Yes,
You've
Your
got
Honor.
to have something from which you could reasonably infer. You have to have some kind of fact from which you could reasonably infer that ultimate finding, or something that would support an ultimate finding of fraud.
Your Honor, there is one other thing that I looked at right here. And I take it, I don't want to speak for the court, but my understanding is that the maintaining of the records by Appellant Martin, that would be a... I'm not saying that you're agreeing. I'm not asking you to do that. I'm just saying I want to focus on Porter Garcia. Right. And I
Maybe,
understand
but in
that's
regard
what
to,
I'm
but
saying.
in regard to the other
Yes. In regards to Porter Garcia, Clerk's Record 86, paragraph 11, talks about, and now this is talking about her statements in the TWC, because at this point we're in, if we're in SLAP, then we can use things that she said in TWC as evidence of fraud, things that were said later as evidence of knowledge before at the time. So a past statement being used to infer a prior knowledge. She claimed that she should be paid for Labor Day. There's testimony in the affidavit that the employees on the first 90 days that they were there, like I said, I know it was less than 90, I don't know the exact number, but that stands out in my head, because if it's less than 90, you're not paid for holidays. There was no dispute that she was not there on Labor Day, but she represented wrongfully to the TWC board that she was owed this time, and she was also owed for Labor Day when there was no... She had never claimed that she was supposed to be owed for that. That's another bad act that can... I mean, we would just say it was a lie that would be evidence of, combined with everything else, that would lead to a argument for an inference, because we're at this normal stage. Now, if we have rested in the trial and we're moving for directed verdicts, it may not be enough. But at this stage, because any fraud claim, that's the bane of the existence of any fraud claim, is showing knowledge at the time, because nobody ever puts anything in writing or says, ha ha ha, we're going to get these guys. So, but through those acts, we argue that at this point, in light of the policy of the TCPA to protect meritorious claims, without the benefit of discovery, that there is argument that we've hung something on that peg for the knowledge.
What about, is there a difference, your theft claim also has an intent element. Is there different evidence, or is this the evidence that bolsters both the fraud claim and the theft claim?
Yes, Your Honor, and I apologize because I remember you asked me about intent.
Oh, no, I asked about both. So.
Intent on the fraud claim is that the appellants made the representations with the intent that the Travis Law Firm act on it. And Justice Coy, you are correct that it is very similar evidence of the two, of that the only reasonable deduction that you can draw from why did they make the statements repeatedly that yes, we'll make it up, and that because at this point we're not challenging whether or not the statements happened. It's, am I hanging evidence on the peg? We're not taking their, well, no, we never said it. We're not looking at that. We're just looking at our evidence. And we said we had an agreement that they'd work and make it up. They repeatedly told us that they would, and they didn't. And that intent was that that Travis Law Firm rely upon, yes, we'll make it up in order to get the payment from Travis Law Firm. So that's to intent. And that they desired to cause the consequences for their act of lying. That is why else lie. And again, that's a fact issue. I grant you. I'm not saying that they've admitted that they've had that contract and they breached it, but that is a fact issue.
So your position is we're disregarding any contrary facts for this purpose. We're just looking if you hang something on the rung.
Yes, Your Honor. That if we put up direct and, clear and specific evidence for each of the essential elements of our claim to make a prima facie claim, then yes. One of the quotes from one of the cases was, it was the minimum quantum of evidence necessary to support a rational inference that the allegation of fact is true. There's no reference in there to and considering what the other side has to say. Now this is not, and I don't want the court to think I'm representing to it that it is a summary judgment where you have to basically close your eyes to everything the other side says and accept all reasonable inferences in favor of the non-movement. I'm not saying that, but I'm saying that it is, you're not balancing in step two, which is hanging the pieces of evidence on the pegs. It's just prima facie. If it said preponderance of the evidence, I agree that the movement would get to say, well, no, that's wrong because look at this evidence. Well, no, that's wrong. Look at this evidence. And you would have to weigh it. But the court doesn't have to weigh it. As long as I check the box, as unfavorable as it may be, of whether would I want to try the case on that right there, probably not as a trial lawyer, but I haven't been through discovery either, so I don't know what their emails or text messages say. Maybe they're out there. I can't do it once they file a SLAPP petition.
You're almost out of time, and I have two more quick questions.
Yes, Your Honor.
Are you contending that the law firm relied on any alleged misrepresentation made after the employment ended?
No, Your Honor.
Okay.
All the representations all the representations that form the basis of that they relied on. I mean, literally everything from and now, but I want to be careful to not say just the employment, because it was from the interview, because that was when all this stuff was discussed. So interview, hiring, till the time they walked out the door. After that.
Okay. And then with the damages piece that I touched on earlier.
Yes, Your Honor.
Is it your contention that the 14 hours that you paid Porter Garcia for in September of 2017 satisfied the terms of the contract, or is it yes or no? Yes.
I'm sorry. Sorry.
Your affidavit said that you were supposed to pay her through September 8th, and looking at, I understand September that year had Labor Day in that time period.
Yes,
but
Your Honor.
How does 14 hours match pay September through September 8th, even assuming 2 weekend days and a holiday?
My understanding is that the way that the payment records are evidence of she was paid what she was there for. That there was some.
It wasn't what she was there for. I thought to comply with the contract, you had to pay her for a full 8 hours a day every day. And
I'm sorry, Your Honor, I'm getting confused. Oh, because 14 hours is not 8 and 8. I'm sorry, I didn't understand your question. Okay, so yes, our position is that the 14 hours was because I'm not saying that they were paid for 40 hours a week, all day, every day. It was if it was a work day, you were paid. So if there was some time off that the firm was closing early or something like that, and no one else was paid, well then they wouldn't be paid.
But September 1 through 8th, if we assume Labor Day and 2 weekend days, that's 3 days off. So
Yes.
5 other days in that time period, or at least 14 hours is less than 2 full workdays. And under your alleged contract and your affidavit, you were supposed to pay them a full 8 hours a day for every workday, and if they missed time, they had to make it up.
Well, they were supposed to be paid for when the firm was open, and that's what I'm saying. Is the only thing that I can think of as we're sitting here talking now is that there was, if the firm closed, maybe the firm closed early for Labor Day, and they got off 2 hours early, and with it being appellant Porter Garcia, because she was a less than 90-day employee, she wasn't entitled to holiday pay. So that's the only thing that I could. But from the payment records and through reviewing, and I apologize, I'm kind of drawing a blank right now, but that 2 hours, I would submit that, and I would submit that by hanging the evidence on there that we've satisfied. But if we're examining the quality of the evidence and how strong of an evidence it is, then my understanding is that it would have been something that would have had to have done with the holiday pay, because it was around Labor Day, and that is in the affidavit, that because appellant Porter Garcia had been there less than 90 days, she was not entitled to holiday pay.
In regard to the applicability of the anti-SLAPP statute, I just want to clear up one thing. Now, my understanding is the law firm did appeal and exhaust its appellate remedies through the commission. Is that right?
Yes, Your Honor.
And then at that point, having lost, the only way to get further relief would be to sue in court.
That is correct, Your Honor.
Under the statutory scheme.
Yes,
Now,
Your Honor. Could I just
Sure.
very briefly?
Please clarify it.
Yes, Your Honor. Because our understanding of the law, the appellants have never shown anything that's different, is that because we had a dispute between us that predates all this TWC stuff, that her filing TWC did not abrogate or do away with our claims, even if they're inside that 180 days. Because the payday law says that they may avail themselves of this statutory remedy, but it's not required on the worker's part. It's not a prerequisite. They don't have to exhaust anything. She could have gone straight to court.
Now,
She chose TWC, that she basically at that point kind of handcuffed us and said, well, we have to go through this, because I think if we'd filed a district court case, they would have said, no, it's being handled in TWC right now, you've got to exhaust that and then appeal it in the district court.
Now, my understanding is the workers contend, at least in a portion of their argument on appeal, they contend that the additional claims brought by the law firm against the employees were retaliatory in nature because the employees had sought relief under the labor code. And as a basis for that, they allege this: these additional claims are retaliatory, and an agent of the firm stated to Martin during the pendency of the TWC wage claim that she would be sued if she continued to seek the unpaid wages through the administrative process. What's your response to that allegation?
Your Honor,
They have a record cite on that.
Yes, Your Honor, and I remember that it was an affidavit or pleading or something. I remember exactly what you're talking about. Our response to that is...
Does that in any way show, well, this was because it relates to her, arises from her statutory right to petition?
That statement in and of itself, Your Honor, that statement standing alone, I agree, is some evidence of a retaliatory nature. But retaliation is not the test of whether or not it applies. That's the first thing I would say about that. Because the test is it based on, related to, or in response to their exercising of a claim? And not only that, we go back to the preponderance of the evidence of the balancing. Now, if we were back in step 2 with me as the non-movement, then her saying that would be an example of, it may be really thin, she may not want to go to the jury with it, may not be persuasive enough, but factually she's got a record of some evidence in there. But when you look at the totality of the circumstances, which the trial court has to do and this court has to do as a de novo review, you have to both be the arbiters of the law as well as the facts. And you have to look at the totality of the circumstances and say, well, of course she's going to say that, because there's this whole thing about 17, 20 days that was well beyond that. So It can be he said, she said, but you have to look at the totality of circumstances. So if your question is that enough alone to drag it into TCPA, we say no, because of the plain language of the statute, that all of this other evidence, there's that one statement versus this entire time of her employment, of her getting paid and not making it up. So there's a balancing that has to be done there. So that's our, is that?
I understand.
Okay.
Thank
Thank you. And Your Honor, I see my time has expired, and I thank
Yes.
the court for its time.
I have a question before you sit down. Have these disputes been mediated?
No, Your Honor.
Okay. Would your client object to being ordered to mediation?
No, Your Honor.
Okay, thank you.
I proposed to walk away, actually, and it was rejected.
Thank you.
So, but I would be willing to do it, Your Honor.
Let me just clear this up. Would you object to being ordered to mediation?
No, with the caveat that we would not waive any remedy, i.e. sanctions, attorney's fees, costs that we're entitled to under the TCPA.
Okay. So we have on the record stipulations from both counsel that they won't object to being ordered to mediation. Okay.
That's fair, Your Honor. Just brief rebuttal, Your Honors. Assuming that the TCPA does apply in this case, or at least as to those three causes of action, the problem that the appellee has in this appeal is, in fact, evidence. In Lipsky, they really do kind of cover or try to decipher what is meant by clear and specific. And there was some discussion earlier about when or whether or not circumstantial evidence can be considered. And I would present to the court that if it can, in a TCPA context, how is a trial court able to weigh that? Meaning, what is the circumstance if they aren't able to consider both the movant's affidavits and then the affidavits filed in response? And Justice Scalia, I'm just kind of touching on your question earlier, which is to say, to further my argument, is that I think that the TCPA does allow a trial court to weigh, it's hard to use the word evidence, but balance the affidavits in order to determine if the non-movant has made a showing of clear and specific evidence of a prima facie case of each one of the essential elements. As it applies, go ahead, Your Honor.
If we agreed with them on this point, walk me through why they have not shown a breach of contract claim in each case.
No
Start
problem.
with breach of contract.
So there are, in our brief, there are two elements that we focus on. One is the existence of a contract, which without that element, obviously, we don't have breach of contract. The argument that there was a oral agreement is strained. Other than just the averment in their affidavit that this thing existed, there's no other support for the existence of an oral contract.
Okay, well, there's no dispute there's an employment relationship here, right?
Correct.
So there's a contract of some sort. There's a dispute about what the precise terms of the relationship are. Isn't that right?
No, because in an at-will context, at-will employment, there is no contract. There's no obligation and requirement to perform and a right to seek remedy if there's a breach.
Why does it change it from being at will? I might say I'm an at-will employee and my boss says to me, hey, you have to do X, Y, or Z. I mean, why would that change your at-will status?
It would not. It would not change it. Under the at-will doctrine, both the employee and the employer can terminate the relationship at any time for any non-discriminatory reason or no reason at all.
Okay, but that doesn't mean there's no contract. That's just a feature of the relationship.
Well, if it does mean that there's no contract, how could that relationship be breached? In other words,
Because it's some other term. Nobody's saying that your clients, could not walk away, and nobody's saying that the law firm was required to continue employing them.
if that were the case, Your Honor, an employer could possibly argue that the requirement that the employees show up at 8 a.m. is a term of a employment contract, and if they don't do it, they could sue them in court for breach of that agreement. I don't believe that that's the case, at least as it applies to this situation.
Well, if an employee has agreed to work for an employer for a certain amount per hour and the employer doesn't pay them, they could certainly sue for breach of contract.
Well, they could sue
The
for...
employee,
they could sue
the
under-
employee could sue the employer for not paying them
They
in
could
accordance to their contract, having worked the hours they said they would.
Yes, Your Honor, that's correct. But conversely, if the employer was to change the rate of pay on Tuesday, on Monday it was $15 an hour, on Tuesday it's $10 an hour, there's nothing...
But
the
for
employer-
work already performed, they'd still be entitled to recover for what they had agreed to.
That is correct. And that is partially thanks to the Texas Labor Code, the Payday Act, which governs a lot
I
of
think
this.
we're kind of, I mean, the point here is, Judge Massengale's point is well taken. There's a contract here. It may not have a term of length, and that's, you know, that's why it's an at-will, that's why it's called an at-will employment, but there are still terms of a contract there, and they're enforceable.
If the appellee has shown by clear and specific evidence a prima facie case for the existence of a contract, they certainly have not as to damages.
Why not? Walk us through that.
Well, first and foremost, so let's talk about the two potential damages that have been alleged in this. The first and foremost one both goes to TCPA applicability and the absence of damages. That is that in their affidavits, they make reference to the precise amount of the wage claim award. Now, they do add in excess of, and they suggest in their affidavits that that amount is an estimation. There's two problems in terms of why our motion should be granted with that. Number one, the amount itself had not exchanged hands. So and in fact, the appeal, right, their judicial review of the wage claim was pending. There was no obligation for them to, at the time it was filed, there was no obligation for them to pay that amount. They were
Your
actively
time's
appealing.
expired, but go ahead and finish
I'm
your
sorry,
thought.
Your Honor.
Go ahead and finish your thought.
They were actively appealing whether or not they had an obligation to pay that amount. The second part of that, Your Honor, it goes back to Lipsky, and whether or not that affidavit reaches the standard of clear and specific, and it does not, because the case law says that those general averments, in fact...
But how is a specific number, general averment? The way I understand it, what they're saying is for each person, they were supposed to work X number of hours. They didn't work those hours. The amount at issue then is the multiplication of, they were supposed to make up these hours. They didn't, so the amount in dispute is the amount of money that would be paid or not paid based on those hours that were missed. And that is the amount that the Workforce Commission awarded.
Right.
And they're saying that they're entitled to that same amount because of breach of contract.
In
Is
their-
that what they're arguing?
In their affidavit, they say that the exact total of the injury is unknown currently, but the injury is in excess of, and this is as to, I believe, Allison Martin, $682.66. Lipsky uses those words exactly, in excess, and says that that's not enough when it comes to the second prong for showing that clear and specific evidence. Arguing or putting in your affidavit, well, it's in excess of an amount, just doesn't cut it for getting them past that second prong.
Thank you. The cases of Porter Garcia and Martin versus the Travis Law Firm are now submitted. Thank you all very much.
All right.